Hello, everyone. Good evening. Carl Steinbeck here. I want to talk about the Charlie Adelson decision that came out today, the appellate decision on his conviction for murder and solicitation to commit murder and conspiracy to commit murder. So, as expected, the court denied all those claims, and pretty much it was something that was very much, as I say, expected, and I'll get into that in a minute. But before I do that, I just want to highlight to you, any of you that have been following this case I've covered the last several days in Tennessee, there in Nashville, the Blaze Taylor murder case. I just want to highlight that there was zero, and I mean zero, direct evidence that he supplied any cocaine or any kind of drug to the victim of this case. The girl that he sometimes dated, which her name was Jade Benning. And so she, however, was a recreational user of drugs and even was dealing drugs occasionally. And she wasn't doing it, though, once she found out she was pregnant. At least that's what the evidence appeared to show. But there was zero direct evidence he was ever involved in drugs, had nothing to do with drugs ever. And yet, by virtue of circumstantial evidence, the jury, quickly came back. It was like 2 hours and 15 minutes later, came back and convicted him of everything except the one charge having to do with Jade herself, because that, as I said, it didn't look like it was a planned murder for her. She just happened to be collateral damage because he really wanted to kill the baby, but what he did do was put way too much cocaine, an elephant amount of cocaine, in her drink, and that killed her within like 30 minutes or so. So anyway, I just want to point that out to you, that any naysayers that talk about, oh, there's no direct evidence and, you got no case and all that kind of stuff. Circumstantial evidence is great because it's like death by a thousand cuts. You can't argue against it. It's not somebody's motive that you're attacking. It's all these little nuggets of information that create a picture with all the pixels in there to show exactly what exactly happened, and you can really then have comfort in knowing you're doing the right thing if you're on the jury. So the jury had the comfort of seeing the big picture. They didn't have all the pixels on this portrait that the prosecutors laid out. But the defense did an absolutely terrible job. I encourage you to compare the closing arguments of the prosecution and the defense. The defense actually bolstered the prosecution by a whole lot. So it's very gratifying to see, and I'm very relieved to see justice was done there in Nashville for the Benning family. So let's move on now to this other development that came out this morning. So it's been a long day of coverage here. I don't want to go too much onto this case. It's not going to take a whole lot of time. Let's see your slide. I'll show you guys the slides as well. So this is what it looks like. The opinion came out today, July 1st, and Justice Rowe was one that wrote this opinion. Actually, it would have been mostly his clerk or his team of clerks that would have written it with his review and supervision and edits. So basically it says here, on the end of the first page and second, there's 5 things that Charlie's attorney Ufferman was appealing on. Number 1, the denial of the change of venue request that the trial attorney Roshbaum had made. Then the denial of the motion to strike the veneer panel. Third was the refusal to enter text messages into evidence. The fourth was extended hearsay evidence, excluding hearsay evidence from the recorded phone calls. And then the last thing was a cumulative effect of all the things denied Charlie a fair trial. So this is initial background here that the court goes through, talks about how basically the evidence that led up to Charlie's conviction, talks even about, the confession of Rivera, talks about McBanois. And then part 2 here is where they get into the actual some of the background of how the jury selection took place. It says it took place over 3 days, called a panel of 50 prospective jurors at a time, read a description of the case, and determined whether prospective jurors were qualified to serve. Due to the publicity surrounding the murder, the court individually asked 130 prospective jurors, some of the form of these questions. What do you know about the case? What are your sources you have obtained knowledge from? Based on what you know, do you have an opinion about Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence that is presented in the courtroom? And can you be fair and impartial? And then the prosecutor and defense were permitted to do also follow-up questions. Keep in mind, there was a breakout room as well where prospective jurors were individually questioned. Some of the media, there was very limited media presence there. So let's see. Out of the 130 prospective jurors interviewed, 96 had heard about the case. 54 of those 96 admitted that they had formed an opinion about the case, and 53 of them believed that Adelson was guilty. The trial court excused all 54 prospective jurors who formed an opinion about the case, and they rightfully did that. That's a no-brainer. And then the remaining panel members returned for group voir dire, and after the trial court and counsel had individually questioned all 130 prospective jurors, defense counsel orally moved for a change of venue. The counsel argued that the prospective jurors' responses during the individual questioning showed that Adelson could not receive a fair trial in Leon County, which happens to be the capital county of Florida, there in Tallahassee, because of the extensive pretrial publicity surrounding Markel's murder. FSU professor Dan Markel, they're talking about, obviously. Counsel argued that, as demonstrated by answers from the mayor of the city, because think about it, the mayor of Tallahassee was even a prospective juror, right down to the citizens of the county, there's not a single person except for one man whose opinion I discount that has said anything other than the man is guilty. As for the prospective jurors who admitted that they had been exposed to publicity about the murder case, but claimed they had not formed an opinion about Adelson's guilt, defense counsel contended that the court should not find them credible. The prosecutor objected to defense counsel's argument that a fair trial could not be conducted. The prosecutor pointed out that in just 2 days of jury selection, roughly 60 of the jurors individually questioned by the court had passed a publicity test. Based on the responses given by the prospective jurors, the court denied the motion. The court noted that several prospective jurors indicated they had no exposure to the case whatsoever. The court further explained that of the other jurors who had exposure to the local media have indicated that they will follow the law and they will render the verdict based solely on the evidence. And the case went on to group voir dire. When selecting the jury, both sides exhausted their preemptory challenge. That's where you have you can strike someone for no reason whatsoever unless the defense raises an issue that there was a equal protection violation because you're excluding someone based on their race or gender. A Batson or JEB Florida is the other decision for race and gender. At the end of the jury selection, the trial court asked Adelson if he accepted the jury. Adelson replied, "Yes, Your Honor." So there you go. He didn't object to it at all. The trial court then swore the jury. Defense counsel did not renew the motion for change of venue before the jury was sworn. So, so you raise a motion, then you don't follow it up after the jury selected. So it's really if you don't raise it after the jury selected, it's sort of like, how is that not a waiver? I mean, you need to like strenuously object, because then you could say you have the facts before you rather than just saying, well, it looks like you're not going to get a fair trial in Tallahassee. You can really say it because based on the jury selection, too many people have their mind made up, and it's just really saturated the community with all the negative publicity. So then here in Part A, Adelson argues that the trial court reversibly erred when it denied his motion for change of venue, depriving of the constitutional right to a trial by impartial jury. He contends that the community was so pervasively exposed to prejudicial media coverage about Markel's murder that it was impossible for Adelson to see an impartial jury. He asserts that prospective jurors who claim to have no information about the murder or claim to have not formed an opinion about Adelson's guilt should not be believed. So really, you're going to have an appellate court do a credibility test. And then the court goes on to cite the U.S. Constitution and Florida Constitutions. The right to an impartial jury is established by common law and also by the U.S. Constitution. And jurors are considered impartial when their minds do not contain any element of prejudice for or against either party and a cause to be tried before him or her, obviously, or when the jurors can render a verdict solely on the evidence presented and the law is given by the court. The test to determine whether a jury has partiality is whether the juror possesses the state of mind necessary to render a verdict in accordance with the evidence and not based on any preconceived opinions. They cite some other cases there. Let's see. But to be impartial, the jury individuals must be ignorant of the cause to be tried. Is that the standard? You can't know anything about the case. And they said not at common law. And it said that then it was expected that jurors drawn from the community would be knowledgeable about the case because they would decide cases based on that personal knowledge. But over time, it was recognized that the convenience gained by an informed jury could be undermined by another very natural and almost unavoidable inconvenience that jurors coming out of the immediate neighborhood would be apt to intermix their prejudice and partialities into the trial of right. And they cite a historic writer of the law, someone that every lawyer would know, Blackstone, very famous author, wrote a lot of stuff on the law. And back in 1768, there in England, to avoid this problem, the American criminal justice system moved away from one impaneling juries with informed jurors to one seeking impaneled juries with little to no knowledge about the case. But even under the modern trend, jurors need not be ignorant of the cause to be tried before them, nor does the knowledge of the cause necessarily render a juror partial. This is true even for juries of trials involving high-profile crimes where members of the venue will have been exposed to some information about the case through pretrial publicity. Every cause of public interest is almost, as a matter of necessity, brought to the attention of all intelligent people in the vicinity, and scarcely anyone can be found among those who best fitted for jurors who has not heard or read about it and who has not formed some impression or opinion in respect to the merits. And so, it's to be expected when murder is committed as well. Pretrial publicity will give rise to the presumption of prejudice among members of the venue only in the most extreme circumstances. So it has to be very extreme. And it goes on to say the change of venue is appropriate only when the general state of the mind of the inhabitants of the community is so infected by knowledge of the incident and accompanying prejudice, bias, and conceived opinions that jurors could not possibly put these matters out of their minds or try the case solely on the evidence presented in the courtroom. So Adelson argues that the pretrial publicity surrounding his trial was so pervasive and inflammatory that it was impossible to impanel an impartial jury, and we all know that's not true. As we will explain, he failed to preserve his arguments for appeal. Wow, that's a dagger. The defense counsel botched something, and he has not met his burden to show fundamental error. Adelson contends that the trial court's denial of his oral motion for a change of venue violated his rights to an impartial jury under federal and state constitutions, but even constitutional rights are subject to preservation requirements. No procedural principle is more familiar to this court than that of constitutional right may be forfeited in criminal as well as civil cases by the failure to make timely assertion of the right before a tribunal having jurisdiction to determine it. Adelson here, it says in here, Adelson failed in two ways to preserve his challenge to the court's ruling. So they're really talking about, they say Adelson, but it's really Rashbaum, his trial attorney. First, he failed to make his motion in writing. That's a big no-no. To secure the constitutional right of a criminal defendant to a public trial by an impartial jury, the Florida Supreme Court has adopted the Florida Rule of Criminal Procedure 3.240. Under that rule, the defendant may move for a change of venue when a fair and impartial jury cannot be had in the county where the case is pending. They cited this same rule again under subpart A. The rule requires that a motion seeking a change of venue be in writing, not verbally on the record in front of the judge in the courtroom there, but in writing. That's under Part B. The rule also requires the movement to attach an affidavit setting forth facts on which the motion is based, and a certificate by the movement's counsel that the motion is made in good faith. So he did none of that. He just made it verbally on the record, didn't have to swear to it, saying it's in good faith, didn't attach an affidavit beforehand where he had any kind of expert that established the fact that this is like pervasive in the community, the knowledge of this case, and everybody knows about it. Everybody knows how Charlie was involved in this case. No, that's not the way it worked, because there weren't those kind of people. It wasn't that pervasive. Adelson's counsel did not comply with the rule in several respects. So Rashbaum, again, is who they're talking about. He did not file a written motion. He never submitted supporting affidavits to show the extent of pre-trial publicity, nor did he certify that the motion was made in good faith. So it's more of a personal responsibility, and they're really holding the attorney accountable to not just, it's not a routine motion. To say you got to do it in good faith, it means you really have to believe that as an attorney. So, Could attorney still make it up, not really believing it, trying to help his client? Yeah, but you're not supposed to do that unless you really believe that this is a genuine issue of concern for your client. You're not supposed to just do some kind of motion just because it's your need to file something on appeal or preserve an appeal right in the trial court setting. So it says here that due to these failures, again, of Rashbaum, Adelson's challenge to the trial court's ruling on his motion for change of venue was not preserved for appellate review. So the court's hands are tied. They can't even look at it. And then they cite another case from back in 65, affirming first-degree murder conviction and sentence of death and holding, so that's a death sentence, where it was unsupported by affidavits. And another case in 86, affirming first-degree murder conviction and sentence of death, holding that an oral request for a change of venue does not preserve for appellate review, but addressing the substantive aspects for the issue to allay any fear that the appellant did not receive a fair trial. And again, they cite another case in 88, noting that the record did not show that the appellant complied with the rule, but reviewing on the merits claim that the trial court erred when it denied an oral motion for a change of venue. So next they say, notwithstanding the failure to comply with the rule 3.240, Adelson failed to preserve his challenge to the trial court's venue ruling because his counsel, again Rashbaum, failed to renew the motion before the jury was sworn. So it's one thing to do it before the jury is seated, before you select a jury, but then after you see who's on the jury and you still believe in good faith that, wow, this is not a fair trial, they all have strong opinions, or it looks like they're trying to set aside their belief. They initially said they believe the defendant's guilty, but the prosecutor tried to rehabilitate them to say, well, okay, I'll keep an open mind. But it just doesn't look like anybody really has an open mind, or enough of them have an open mind to give a fair trial. So what they say here then is, they cite another case from 21 that says, explaining the defense counsel failed to preserve a challenge to the trial court's ruling on venue motion because he did not renew the motion before the jury was sworn, and he renewed a claim for fundamental error. Then they cite another case where they did not preserve it, so I won't go into every one of these. The purpose of preservation requirement is to place the trial judge on notice that an error may have been committed and to provide him an opportunity to correct it at an early stage of the proceeding. The preservation requirement prevents a defendant from standing by silently while an objectionable jury is seated, and then, if the verdict is adverse, obtaining a new trial. So you're not going to play gamesmanship like that with the rules. If you got a problem with the jury, you better cite it and comply with the rules. Otherwise, it's null and void, it's waived. Explaining that the failure to renew an objection given the impression that defendant was satisfied with the jury selection. So that's another case they cite. So yeah, there's plenty of case law they cite to support these bedrock principles. Here it could have been that after voir dire, Adelson and his counsel were satisfied with the jury seated for trial and made a strategic decision not to renew the motion for change of venue. Adelson's counsel did not renew the motion before the jury was sworn. Because he failed to preserve this issue before, we affirm the trial court's ruling on the venue motion. Adelson cannot show that the trial court fundamentally erred by denying a motion for change of venue. If you don't comply with the rules, you waive it, even if it's a constitutional right. An error is considered fundamental when it reaches down to the validity of the trial itself, to the extent that the verdict of the guilty could not have been obtained without assistance of alleged error. They're citing a case there from 2019, and as well as another one that it was based upon all the way back to 1960. And they're saying that Adelson cannot show fundamental error on this record. When ruling on a motion for change of venue, the trial court must consider, then it talks about the extent and nature of the pretrial publicity, difficulty in encountering actual jury selection. And they say, starting with the second prong, difficulty in selecting a jury, it said the Supreme Court instructed trial courts to the endeavor of impaneling a jury before the ruling on the motion for change of venue, explaining that voir dire affords an opportunity to determine whether an individual have not been seriously affected by publicity can be found. It just makes sense. It's better to interview them rather than just presuming based on what you think the media coverage is that you don't have enough fair and impartial jurors to sit for the trial. And they said the trial court followed those instructions in this case. To determine whether impartial jurors could be found, the trial court began individual interviewing 130 They examined jurors to determine the extent of their knowledge from pretrial publicity and assessed whether they had formed opinion about the case. Most of them, 96, had heard about the Markel murder. Of those 96, 54 formed an opinion about the case, and all but one of the 54 concluded that Adelson was guilty. Still, none of those jurors who formed an opinion about Adelson's guilt served on the jury. So if you had a fixed opinion of guilt, you were tossed. You were not going to sit there for this trial. Judge Everett did the right thing. And then it goes on to say that indeed the trial court erred on the side of exclusion when the court perceived that any juror had potentially prejudged the case. So they're saying that, look, Judge Everett was actually looking out for you, Charlie Adelson. The record as detailed below also reveals that jurors actually seated had very limited knowledge of the case. Of the 12 individuals who were selected to serve, 7 reported that they did not regularly watch the news. 4 others had heard about the Markel case on the local news or read about it in the local newspaper, and 1 juror heard about the case on the radio. And then they go on to cite some different jurors. Juror AM said that she had briefly seen something about the murder on a TV station last year, yet she maintained that she had not formed an opinion about the case because she did not know Adelson. She repeated this sentiment during group voir dire when defense counsel asked if anyone did not believe that Adelson was innocent until proven guilty. She responded that it was unfair to make an assumption about people and that she would need to hear the facts. Next juror, BG, remembered hearing about the murder when it happened 10 years ago, but she did not regularly consume the news. Remembered seeing a preview for a TV special about the murder, but she did not watch the special. In fact, she was unaware that there was more than one special until the defense counsel mentioned it. Another juror, TB, said that he had seen something about the murder on the TV, but he only watched the news in spurts. When asked if he could be fair and impartial, he said absolutely. So some of these others, I won't go into each one of them. They said the same kind of thing, basically. Didn't form an opinion. Will keep an open mind. Can be fair and impartial. And it goes on to say that what all these seated jurors had in common was that they communicated to the trial court they had not formed an opinion as to Adelson's guilt and were able to convince the trial court that they could be fair and impartial. Even so, Adelson insists that the jurors were not being truthful when they stated that they could be fair and impartial and set aside any knowledge of the murder stemming from pretrial publicity. So they're all a bunch of liars? I mean, where are you coming up with that? Talk about trying to throw something against a wall that has no substance. So some of you say audio is good and bad. I'm sorry about that. I'm going to try to do some technical workaround. So anyway, we have here him saying that the jurors weren't truthful. He invites this court to look behind the jurors' responses and the trial court's credibility determination, and we must decline the invitation. This is because we must afford great deference to the trial court's decision on whether the prospective juror is able to lay aside bias or prejudice and render his verdict only upon the evidence presented in the instructions of the law given. I don't need to cite this other case law. On the record, Adelson has failed to show the trial court encountered difficulty in seating an impartial jury. After questioning 130 prospective jurors over 3 days, the trial court evaluated their credibility and determined they were seated could be impartial. And nothing in the record supports the argument that any of the seated jurors were not impartial. So, and then it goes back to some other tests. Let's see. Now, other things they look at is the amount of time that's passed from the crime to the trial, whether the publicity consisted of straight factual news stories or inflammatory stories, whether the news stories consisted of a police or prosecutor's version of the offense to claim to the exclusion of the defendant's version, the size of the community question in question, and whether the defendant exhausted all of his preemptory challenges. Generally, the trial court can make a determination on publicity factors from affidavits and other evidence submitted. And defense counsel, they cite another case where they could, submit affidavits from 15 people saying that they can, in their opinion, they could not receive a fair trial. I think I remember that being done in Donna's case, some guy coming in to testify from Kansas City or whatever, but that didn't happen in Charlie's case, right? So Adelson presented no evidence, nor he did make any argument on appeal about these factors. He relies only on the response of prospective jurors. And it goes on to say the presumption of prejudice attends only to extreme cases. So did this publicity bombard, as they use the word bombard, the community there? No, it did not. So was it the state of mind of the inhabitants of Tallahassee so infected with knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors cannot possibly put the matters out of their minds and try the case solely on the evidence presented in the courtroom? No, this is such a stretch. They talk about the 10 years that have passed. I mean, it's basically a cold case at that time. It took them so long to prosecute him. Most prospective jurors learned about Markel's murder through news outlets like ABC, CNN, Fox, Tallahassee Democrat, newspaper, local TV station. Nothing in the record suggests that these news sources are saying anything other than factual, or that the reports include anything inflammatory about Adelson. And then they go on to complain about characterizing Leon County as a small community, but the characterization is inapt. And they talk about the size of the community. Leon County had 292,000 residents in 2020. And then they talk about what the cases that the court looks at historically. The Foster and Rollins case were over 25 years old when people relied on newspapers and nightly news. And he goes on to say now there's 24-hour social media commentary. There's podcasts, algorithms sending repeat reminders, discussion threads, allowing community members to reinforce one another's views. And they didn't have streaming platforms releasing case-specific content on demand. But they said that Adelson not presenting affidavits or any evidence showing the extent of social media or podcast coverage and how that coverage affected the venue. All right, so sounds pretty straightforward. Adelson emphasized that of the 130 prospective jurors interviewed during jury selection, 96 had heard. We've already heard about that. And then they talk about the Rollins decision. That was a case in Gainesville, Florida, where the guy murdered 5 college students over 4 days in 1990. I remember hearing about that case. So 5 murdered over 4 days. I mean, that town was freaking out. The campus was freaking out. The case garnered nationwide attention. He sought a change of venue, arguing that during the 3.5 years after the murder, the publicity was so pervasive. The Supreme Court rejected the argument, explaining that pretrial publicity is normal and expected. So yeah, I mean, that's how high the burden is. So basically, you got a serial killer on a college campus, and everybody's freaking out. Probably a lot of kids went home, wouldn't even go to class anymore. So I mean, sheer panic and paranoia in that community. And then they cite another high-profile murder case. I won't go into that, but anyway. Yeah, then he go on and talk about again that, oh yeah, 54 had formed an opinion of his guilt. Okay, but they weren't seated, so what's that going to do with anything? So that's supposed to have a carryover effect to the others who were interviewed, and that they're going to be lying because of that. Yeah, the trial court was careful excluding juror who potentially was prejudiced to the case. All right, so basically that one's flushed, rejected by the court. And then it goes on to say that the trial court erred when it denied his oral motion to strike the entire veneer because the comments made in the jury assembly room by some of the prospective jurors when jury selection began, the trial court instructed prospective jurors that they should not discuss the case while waiting in the assembly room. Even so, the parties discovered during jury selection that some individuals in the assembly room were ignoring the court's instruction. One prospective juror reported that someone in the assembly room had stated that it was a federal case, while another one said the case must be about the FSU law professor, which it was. It wasn't a federal case, obviously. A different person complained that they would be there a long time after learning that the veneer was not abiding by his instructions. The trial court returned to the assembly room and again instructed the prospective jurors that there was to be no discussion concerning the subject matter of this case until they were excused from jury selection. Defense counsel then moved to strike the jury panel, arguing that it was impossible to know what else had been said in front of the prospective jurors in the assembly room. The trial court denied that motion, concluding that he did not have a basis to strike this entire panel as to a group right now. And the trial court continued with the jury interview. Two other prospective jurors then reported people talking about the case in the assembly room, with one reporting that someone had said Adelson was guilty. Defense counsel again argued that the pool of prospective jurors had been tainted and renewed his motion to strike the panel. Reports of the prospective jurors discussing the case in the assembly room concerned the court. To alleviate the problem, the court offered to allow all parties to watch the recordings of the assembly room to see what was being said. At that point, defense counsel did not take up the court's offer. Why wouldn't you take your offer up on that? You want to know who's saying the guy's guilty? So is he lying to the court, him or her? At that point, defense counsel did not take up the court's offer, but then the court then denied the motion to strike the panel. The court added that if any independent investigation by the defense counsel uses information that would demonstrate otherwise, I will reconsider the motion. Despite the trial court's open invitation, for the defense to further investigate the issue and report back, nothing in the record of the parties' briefs indicates the defense counsel ever accepted the trial court's offer to view the recordings or to further investigate what might have been discussed in the assembly room. So there you go. Rashomon just completely sat on its haunches, didn't do anything to flesh out these details. I mean, does that sound like an effective counsel to you? Even so, Adelson argues the trial court abused its discretion in denying the motion to strike the veneer, but he failed to preserve his argument for appellate review by not filing his motion in writing and by failing to renew his motion before the jury was sworn. And again, it cites the federal rule, or the Florida rule of criminal procedure that requires it to be in writing. So an oral motion is insufficient. Adelson claims fails on preservation grounds for a second reason, not just one, but two here now. To reserve jury selection for appellate review, a defendant must make two objections: a contemporaneous objection that puts a trial court on notice, and a second objection before the jury is sworn. By not renewing the objection before the jury was sworn, it's presumed that the objecting party has abandoned any prior objection he or she may have had and was satisfied with the jury selection. So yeah, if you basically don't renew it after the jury's seated, and then the judge asks, Charlie, are you good with this jury? And he says, yep. Then what do you got? You basically waived it. There's not a point of error anymore. And then it says here that the record shows that Adelson's counsel failed to make a second objection while counsel renewed the motion during jury selection process. He did not renew the motion again, nor did he accept the panel subject to his previous objection before the jury was sworn. So he could say, well, I renew my objection, but I'm not going to make any other claims. I just renew it. And then even if we were to review his claim for fundamental error, Adelson did not meet his burden to show that the trial court fundamentally erred when it denied his motion to strike the jury panel. So even if it wasn't an issue of preserving it, they're saying, look, you got nothing here. Let's see. There was factual statements about the case and legal conclusions about Adelson's guilt. There's Adelson asserting that two type statement made by the prospective jurors supported the motion to strike. So those are the 2 points. And then as the court says, none of those statements were sufficiently prejudicial to warrant striking the jury panel. As to factual statements, record shows that one prospective juror reported that someone in the assembly room said that they thought it was FSU law professor and that the case was about the murder of a professor. That prospective juror added that she believed that they had kids. I think it was a divorce. The same prospective juror reported that the one person said, we're screwed because we're going to be here all day. A different prospective juror represented that individuals had been talking about the case the entire day. I'm just... Wow, the people just don't follow judges' instructions very good, do they? For the statement of one veneer member to taint the panel, the veneer panel must mention facts that would not otherwise be presented to the jury. None of the prospective jurors reported anyone in the assembly room were discussing details of the case, much less details that would not later be reviewed at the trial. None of these factual statements were so prejudicial to taint the veneer. In other words, like, oh yeah, it's a FSU law professor, and oh yeah, it's involving a divorce with kids. As to the legal conclusion, the record shows that one prospective juror reported to the court that she heard someone in the assembly room state that they believed that Adelson was guilty. Yet another prospective juror reported that she heard someone say, I think he did it, but the expression of the prospective juror's opinion generally is insufficient to taint the remainder of the jury veneer. Prospective jurors are frequently exposed before, during, or prior to innumerable comments, attitudes, and points of view, the subscription to which would be improper for an unbiased juror. Yeah, so in other words, if somebody raises their hand and says, yeah, I don't think I think sitting there, I think he's guilty. I mean, does that prejudice the entire panel? So the entire panel must be stricken, all 50 people? It doesn't work that way. You can't impugn that there's that kind of contamination across the entire panel. It says here the trial court is in the best position to determine whether such statements tainted the entire jury panel by questioning the remaining non-offending prospective jurors. To hold otherwise would impose a per se reversal rule, undermining the trial court's discretion and effectively impugn the integrity of the remaining jurors who are able to disregard their inadvertent exposure to the boorish and insolent antics of their fellow citizens. So if you got some, basically they're saying if you got some kind of a person that's just blasting prejudicial comments, oh, I hate this guy, I hate the defendant, I think he's guilty. Is that gonna prejudice all 50 people that are there in jury selection? Or however many they have? No. That makes no sense. What's more, Adelson concedes that the trial court removed for cause any prospective jurors who admitted to talking about the case, but he suggests that this remedy was insufficient because it was unknown how many members of the jury were exposed to the conversation in the semi-room about the case. But they afforded the defense the opportunity to review the recordings for the exact same reason. The counsel declined the offer. So they're just playing legal grandstanding maneuvers here. The defense is, based on the record, the defense failed to show that any of the statements made in the juror assembly room tainted the jury panel, and thus the trial court did not fundamentally err when it denied the motion to strike the panel. Finding no error by the trial judge, the judgment and sentence were affirmed. And these two other judges concurred, so it was a 3-judge panel. And there you can see the appellant, which is Charlie's attorney, Michael Ufferman, and Laurel Cornell Niles of the Ufferman Law Firm. And then for the Florida Attorney General's office, you got a James Uthmeyer, very similar name, Ufferman, both German names, and Robert Charles Lee, Assistant Attorney General in Tallahassee for the appellee. So there you have it. So what we didn't hear anything was about the third point, refusal to, the court trial judge refused to enter the text messages as the evidence. And then also the extended hearsay evidence from the recorded phone calls. That text message, remember, I think that's the one where they're trying to get in. I don't want to mix that up with Donna, but there was something that they're trying to show to complete the record kind of thing to, had to do with the messages, I think involving the hitman or something. But anyway, cumulative effect and all that, the trial court did not address the last 3 remaining prongs. So they just obviously thought that they were just so irrelevant and frivolous. So now, all right, you guys are saying low volume. All right, just going through the case here. If you have the questions, please put a red question mark. Okay, Lee from Tennessee. I know you're there in Nashville, following the case that we've been working on that concluded today there with the conviction of Taylor. So, well, Charlie's gonna appeal to the state Supreme Court. They probably will not hear it. I don't think there's an automatic right of appeal for their, if that's denied, it's going to take some time for them to decide whether they deny it or not, so that's going to take some more time. And then they're going to do, after they exhaust their remedies through the state court appeal process, then they're going to do another type of appeal that starts from scratch, which is done at the trial court level, then the Court of Appeals and the Supreme Court, an effort to do that, and then you also have an option to go the federal route. So if you keep in mind what we had for the ruling by Judge Everett ruled that Rashbaum was committing an ethical violation under the Florida disciplinary rules for attorney conduct, and by doing so, saying Rashbaum was conflicted representing Donna after he'd done represented Charlie. Keep in mind that when it comes out that Rashbaum was representing Donna a couple years before he represented Charlie, and then you have this issue here where he basically just bombed it in representing Charlie to preserve his rights for appeal. This whole thing is just mushrooming into more and more of so many ways of looking like Rashbaum just failed on so many levels in such a degree of doing his constitutional duty to zealously and ethically represent Charlie that Charlie didn't get a fair trial. So before, I thought it might take all the way up to the Supreme Court, beyond the Supreme Court, and have a federal district judge toss his convictions before anything happens. But I'm thinking it might happen sooner. If you got Rashbaum committing all these horrible, egregious errors, then it just makes it look like he fell asleep at the switch, and what Ufferman's going to do is make it look like he intentionally was sandbagging Charlie's case. So these guys are privately retained, Lisa Burt. So this is something that Harvey's paying for, money from Harvey and Donna, Charlie's dad, who's had millions of dollars, but they're burning through it pretty fast. So then here, Chris Forbes, you're asking, what motivation would Charlie have to turn on Wendy other than spite? Is there any other impactful advantage? Well, I think what's probably happening behind the scenes is that Ufferman's telling him, look, we're not going to win on this direct appeal. What we're going to have to do is wait to come back later and do an attack on ineffective assistance of counsel. We're going to go after Rashbaum, and we're going to say he's conflicted. He went from bouncing between you and Donna, and it looks like he was in the tank and hurting you to help Donna. You get the conviction, puts pressure off of Donna. They're probably not going to go after Donna because they'll be satisfied at least one Adelson was prosecuted, and it's more circumstantial for Donna than it is for you, is what they're probably telling them. So your best option is to wait and see. It's a wait and see game, and what happens then is once Charlie's conviction is overturned, which is what I predict, at some level it's going to take a number of years, I think, because think about it, unless Judge Everett, once his direct appeals are done, once he does this secondary appeal, what's going to happen is I think Judge Everett might find that Rashbaum was conflicted. I think he was so incensed that Rashbaum had gone from one to the other Adelson, both facing murder charges, that if Rashbaum says that basically that he was ineffective, which I hope, I'm sort of like wonder if he might. A lot of trial judges are just going to automatically deny this kind of relief. They don't want to set aside a murder conviction. They'll let the appellate courts do that, so they'll sort of like kick the ball down the road. So what happens here, though, I think Rashbaum did such a bad job not staying away from this massive conflict of interest issue. And keep in mind what I've been saying all along is, like, if you have a conflict that's an ethical conflict is such a magnitude that you can't even fully informing your client, they can not knowingly and intelligently waive it, is a constitutional error of that magnitude. That's what we have here. You cannot have Rashbaum fully, ethically, and zealously representing both parties. And I've said, if you have a situation like this in Texas, for example, if I was defending this case and I had the same history on as Rashbaum does, representing two parties that are both related and they're both charged with first-degree murder, and they're sequentially charged, one charged after the other one's convicted, then guess what happens? There's no way I would be in the position to represent either one of them at that point. If I've been representing Donna and then all of a sudden Charlie gets charged, and I'm like, oh hey, well I'll go represent you, Charlie. One of the things that you have a duty to discuss, like, hey, well, all right, is there anything you want me to do to negotiate a plea agreement? And that, if he cannot even offer that because he's representing Donna, because that wouldn't necessarily implicate, hey, do you want to flip on your mom, who I used to represent? And so that's the conflict. That's the constitutional conflict. And so now that we see Rashbaum being so inept and so incompetent in representing Charlie and preserving these appellate right issues, I think it just helps the overall level of what do you say, dereliction of duty that Charlie was denied a fair trial. So I look at this thing here and I go like, wow, it's more ways that Rajram, in essence, sort of sold him down the river, right? So it doesn't have to be that Rajram was trying to do anything to sell him down the river, right? But if you make so many fundamental errors, you don't fully advise on the conflicts issue. Keep in mind he did not get anything in writing. But I've said all along that you cannot waive this kind of conflict. On two contested murder trials, you cannot waive it. If you're trying to do plea agreements that wouldn't be as harsh, if both these guys had pled out, Donna and Charlie, if they both pled out, could you represent both on murder cases? If you got really good deals or otherwise strong cases, which these were, then if you got maybe 20-year sentence out of for both these clients, no one's gonna complain about that. So anyway, here it just reeks of conflict all over the place. It's just contaminated. This case is contaminated. So yeah, I think Rajram could be sued for malpractice. Sure. It just looks so bad. Like he was willing to let Charlie get thrown under the bus to help Donna. Yeah, so I've already answered this question about malpractice. Yeah, I mean, I think Donna does because you got Judge Everett already saying on his opinion where he tossed all the defense attorneys, and that's something else I was saying. If you remember, I was saying like Rajram can't hire other attorneys and say like I'm just hiring you now to handle the non-conflicted part of the case. The whole team is conflicted, the whole team, and the judge had the authority to bounce it. The prosecutors didn't even know that. And what happened? Judge Everett, citing the Supreme Court case that I cited a few days prior, he used that Supreme Court opinion and said, look, I have the authority. All of you guys are gone. Rajram, you committed an ethical violation. So that's why this case is basically falling apart on appeal. It's going to fall apart, and what's going to happen is Charlie's going to have a chance to start over from scratch. And so if Charlie's starting over from scratch, the convictions are set aside. He's got these 3 convictions that they're set aside. Guess what? You can start a whole new plea bargaining all over again. And if you're telling me Charlie's going to be in jail, he's actually in prison, there in South Dakota, he's going to spend a number of years in jail, more than what he has so far. He spent a couple years behind bars already, including pretrial. So think about it. He was in jail pretrial. Now he's been convicted over 2 years ago. So he spent 4.5 years. Is it 4.5 years now behind bars? Something like that. Don't quote me on it. But it's something where I would think that he doesn't want to go to trial again. I think he's going to be fuming that somebody else in his family has been walking around without any kind of prosecution whatsoever. So, yeah, I would think if he has unconflicted counsel, they'd be saying, hey, who else can you offer up as a part of this that the prosecution hasn't gone after yet to indict? Are you willing to testify? Tell me how you're involved in this. So, because if he fights this again, he's just going to get convicted again. The prosecution is not going to have another conflicted counsel issue to deal with, I would imagine. And so any appellate issues are not going to have any success at that juncture. So the judge is on to him now. The conflicted issue. These I should say the Adelsons haven't done the best job of selecting their counsel, have they? So, and as we've seen, look at in these cases, look at the degree of representation, quality representation of the cases that we've seen here in recent times. Look at the case there with Corey Richens. She had 3 attorneys there. Look at the effectiveness that they had. Look at Charlie's attorneys. Look at Donna's attorneys. Right? So look at the attorneys of the case I just covered, the ones from Houston that were up there in Nashville. I'm not impressed with any of these guys, folks. Are you? The only ones I'm impressed with is the ones up there in Massachusetts, Karen Reed Defense Counsel. So, Yeah, it's amazing. It's amazing. The one thing that that I've not seen in any of these trials is the defense counsel attacking the government's experts based on their financial motives. Okay, we saw Brennan attack the financial motives of ARCA in the Karen Reed case, but you know what? Defense never asked how much was Ian Whiffen getting paid, right? We don't know. How much was he getting paid to testify against Karen Reed? How about that other one with the scarf around her head? She was also a computer IT person, an expert with her own company. Oh gosh, I had her name a second ago. But anyway, so that's one thing that's the only thing I really was that I can think of that I was shocked that that was missed by the Jackson team that stood out. But you know they fought like crazy for preserving the constitutional rights of Karen Reed. It's the worst case of railroading I've ever seen. So if you got anybody wants to go back and look at that case, Jessica Hyde, thank you. Yeah, it was Jessica Hyde. How much was Jessica Hyde paid? Right. Um, I think the blue man, the guy from Dallas that also had his sidekick that falsely represented his credentials, including his college degree, said he had a bachelor's from University of Alabama when he was working towards it, like the perpetual working towards it, and he got fired shortly thereafter from the company, shortly after he testified. So, yeah. So anyway, Jed Welcher, yeah, that's the blue man. Yeah, for that certain company, I forget what they're called. They're there in Arlington, Texas, in the Dallas-Fort Worth area. Yeah, yeah. Bloodworth was great. An Army JAG colleague of mine, who I've never met or don't know. I'll have to give him a call one of these days. Cowboy Girl, yeah. Blaze Taylor's attorneys were so annoying. Sorry, the sound is bad. I'm gonna have to figure out what's going on here. 10:52. Yeah, I've been going on starting. I've been going on 52 minutes here. Yeah, well, Karen Reed's lawyers. I mean, look how good Jackson was. Good. Look how good Alessi was, and Yannetti. I mean, Yannetti lives there, and he took on this corrupt system. I mean, you talk about a guy with nerves of steel and courage and guts. Well, all these guys. I mean, those that system up there is ruthless, crushing people, trampling on their constitutional rights. Fletcher boy, any chance Florida Supreme Court takes this up? There's a chance. There's a chance. But this is such a. I think this case is so weak that there's a chance they can flush it and just say we're not going to take it up on appeal. Then that would be the case. Yeah, I think it's too early for let's make a deal time. I think they're going to try to get everything thrown out, and then we have it. He has a chance to start over from scratch. Because think about it, if he would want to cooperate now, without having his convictions tossed, his sentence may not get reduced much at all. Even if he flips on other people like Wendy or his dad. Yeah, John's right. It is a total gong show. Total gong show. You're right, John. And John's the one that got me onto this case, the Adelson case. So, lo and behold, this case is still going on, and I think that, gosh, how long could this possibly still go on for? This could go on for another decade, I think, when it's all said and done. John Smith is saying, do I think this is the time for Ufferman to have a come to Jesus talk with Charlie and tell him to come clean? No, I just answered that because he's not going to get much out of it. He could have all the receipts on Wendy and his dad, let's say, to cut a deal, sweetheart deal, but there's no deal to cut at this stage unless he's getting his convictions tossed and he starts from scratch. There's just no guarantee. It's up to whatever the court decides to reduce the sentence by, and that's just too much of a risk. Think, for example, the Katie McBanois situation. She testified naked, as some of us call it, where she had no guarantee of anything. She's thrown herself under the bus, and she was also testifying, and she helped convict. She helped convict Donna. So, and look, what has she gotten for it? Nothing as of yet. And she may not get anything. She still may get nothing out of it. Skier, you're saying I called it 2 years ago. That's how tone deaf Rashbaum was. Yeah, I kept it quiet when I saw him going from Donna to Charlie. I did not say anything at that point. But when he went back to, but I knew I didn't want to, like, I guess, taint the process and give him like I say, I never want to help the Adelson lawyers out, so I didn't want to like come up with that as a reason. But once I knew that he then went back to Donna, I'm like, okay, I'm going to discuss the conflict now. It's being raised in court for the first time, and that was something that was going over like a lead bomb, and it was you never are going to get this thing fixed, in my opinion. Nothing's going to fix it. All the waivers in the world would not prevent Charlie and Donna from having a constitutional, conflict-free representation in their trials. Nothing would fix it. You know what's funny, though? Also, I just got done recently finishing a 29.5 advanced criminal law course here in Texas, where all these different attorneys come in talking. And one of the attorneys actually mentioned that, nobody's going to represent somebody in co-accused murder trials. He said something like that, and I'm like, wow, if he only knew about the Adelson case in Florida. So, yeah, it's just like a no-brainer. It's a no-brainer, yet everyone was asleep at the switch there in Tallahassee. Thanks for doing the red question marks. Makes it real easier for my eyes to see if you have a question. My 3 cents. Please explain how losing this appeal helps or hurts prosecutors moving forward with the case against Wendy. Well, I think if the Court of Appeals tosses conviction now, assuming the state doesn't appeal to the Supreme Court and then they reinstate the convictions, then I guess that would be ideal, because then he could start from scratch all over again. But like I said, these are these are appeal points that are not going to win. He got a fair trial in that respect. The only way Charlie didn't get a fair trial was due to the conflicted counsel issue. That's the only thing he's got. So, and it's too early for that to be raised. And so, because it's premature, he's just going to have to wait it out a number of more years. Skier, you're asking ethical violations, what does that translate in terms of penalties? Rashbaum could be in trouble with the state bar. He could get disbarred, suspended for some time. So it's really up to the Florida bar, and this is going to make it up to the Florida Supreme Court as well. So think about it. These same judges on this Court of Appeals, they're not on the Supreme Court. They won't be deciding anything for discipline against Rashbaum, but is there somehow this is going to come out in the malpractice, or excuse me, in the ethical accusations made against him? I think it could be. I mean, he's just going to have a bad reputation for doing this. Already answered this. Who pays for all the appeals? The Rashbaums, the Adelsons are paying for it. Law and Lit. I think that this expensive jury consultant may have made Rashbaum less likely to take this issue more seriously? I think I don't think he really believes this, that he wasn't getting a fair trial. And so would he have still done it if he would have known he needs to certify it in good faith and swear to it and sign it? I don't know. I don't know what he's willing to do for Charlie. I hope he wouldn't lie in bad faith. I mean, a lot of attorneys do in criminal law. They do motions that they know they're not going to be granted, right? So this is, like I say, a higher standard. I'm just backtracking on some of these questions here. The Skeeter girl, you're saying Charlie will turn on Wendy since Donna stipulated evidence against her handwriting analysis. Charlie can't help her, so why not go after Wendy? So Yeah, that's what I've been predicting is going to happen. So yeah, there's a number of appeal process still left here, Larry Hudson. Two two rounds, two different tracks. One has to be completed before the other. Thanks, Larry. Yeah, John, my volume is too low. I don't. It's I haven't changed anything. I've maxed everything out, so I think something's wrong on one of the systems here. Yeah, Dinah, my sound is maxed out, so there's something going on. Other people's sound is fine. Yeah, isn't that weird how some people's sound is fine and others? Let's see here. Zelda Fitzgerald, can we all write to Charlie to egg him on to turn? I think you mean against you know who, Wendy, and possibly Charlie. Um, I'm not going to encourage people to do that. Can you write a letter to him in South Dakota? I'm not sure what their rules are. Does he have a list of people whose mail he has to accept or something like that? I'm not sure. But that was asked by me just about a week ago. Somebody asked me that I was talking to. They're saying, "Hey, they're asking me if I could write to him?" And I'm like, "No, I can't write to Charlie. I can't act as as a lawyer wannabe for Charlie to help him out that way." So let's see what else here. Zelda again. Will they wait and arresting Wendy until all this appeal stuff is over? Boy, I hope so. If they don't have any intent of arresting her at all, it's like I think they're going to be forced to have to deal with this. So once Charlie's conviction is overturned, if Charlie's conviction is overturned, it's going to take maybe a different district or state attorney because Campbell just doesn't have the fortitude to go after this. I mean, the Markells want justice done. Justice is not done, they said, until the last person's held accountable that was responsible for killing their son. So they're not satisfied, are they, without justice being finally completed? So they're like halfway there as far as the Adelsons go, I would say. But I'm just hoping, trusting, and praying that justice is going to come out the where their hand is forced. Either spontaneously get some courage and a backbone to do justice for the Markells, or something forced their hands where Charlie's offering up on his own through his counsel to say, "Hey, I got the goods you need to convict my sister." Mary Stillman, you want Karen Reed's lawyers? So, all right, let's see. I'm going to. One thing I have to say, I've been saying this every day that Charlie's in jail and his sister isn't is a day that I think increases his motivation to flip on her. What do you all think? Yeah, Florida corporate. I thought you had to be approved to write a letter of visit. I don't. Different states have different rules. I mean, some of these murders, they have all these love letters and stuff like that sent to them. Did John try calling me? Hold on a second. No, I don't see anything. All right, so with that, I'm going to go ahead and sign off now, folks, and we'll have more coverage on this down the road. Not doing too much stuff on Adelson's, as you've seen, because I'm just incensed that stuff not moving along better, and I just want to move along and not keep beating the drum on this. And there's other cases to cover, and we had a great case to cover here this past week and last week as well up in Nashville there. So anyway, lots to be learned about justice. You guys can see some of these patterns now. So what kind of pattern recognition do you see about all these folks? Compare the folks that have money and those that don't. So think about it. Corey Richin had all this money for attorneys. The case we just got done with in Nashville, they had all this money for attorneys coming from Houston, and all the experts were from Houston. They had so many different experts from Houston. And then what else do you have? You have the Adelsons in Florida. They have all this money. And then, of course, you have the Karen Reed situation. That's different because she was set up. So there you had an outpouring of support from across the public about all the scandalous stuff going on up there in Massachusetts. So anyway, thanks everyone for your wishes and prayers for my sister, and she appreciates that as well. So with that, I'm going to go ahead and sign off. Oh yeah, Shanna Gardner, she's another one. I want to cover that one as well, so we'll see how that one turns out. Anyway, so you all take care. Have a great 4th of July weekend, and we will be back sometime covering another case. I've not decided which one yet. If you do have a recommendation, please send me that to jurytrialmentor@gmail.com, jurytrialmentor@gmail.com. So y'all take care, be safe.